Section 2. Ethical Responsibilities of Real Estate Professionals in Distressed Property Transactions. Disclosure Obligations in Short Sales. Ensuring transparency for the seller and lender objective. This section will explore the ethical and legal responsibilities of real estate professionals when representing distressed homeowners in short sales, focusing on the importance of transparency and full disclosure to both the seller and the lender. Real estate professionals play a vital role in protecting their clients' interests while maintaining ethical standards throughout the transaction process. Understanding disclosure obligations in short sales. In a short sale, the homeowner sells their property for less than the amount owed on the mortgage, and the lender agrees to accept this reduced payment as full satisfaction of the debt. The real estate agent's role is critical in ensuring that both parties, the homeowner, seller, and the lender, are fully informed about all aspects of the transaction. This involves making sure that all relevant facts are disclosed to avoid legal consequences and maintain the integrity of the transaction. Transparency is crucial. In short sales, transparency between the seller, the lender, and any third parties, such as investors, is key to ensuring that the transaction is completed legally and ethically. The agent must act as a fiduciary, prioritizing the client's interests while adhering to ethical standards. Full disclosure. Full disclosure refers to the requirement that real estate professionals inform all parties involved about any material facts or conditions that could influence their decisions. Failing to disclose relevant information could lead to legal issues or even the cancellation of the transaction. Key disclosure responsibilities for real estate professionals. Real estate professionals have a duty to ensure the following disclosures are made during the short sale process. Seller's financial situation. The agent must ensure that the homeowner's financial hardship is accurately represented to the lender. This includes providing a truthful hardship letter and appropriate supporting documentation. Example: if the homeowner is behind on payments due to job loss, the hardship letter should provide clear and honest details of the situation. The agent should not misstate the reason for hardship or overstate the homeowner's financial situation. Property condition. The condition of the property must be disclosed accurately. If there are defects, repairs needed, or other issues that might affect the property's value or desirability, these should be disclosed. Example: if the property has significant structural issues, such as foundation damage or a leaky roof, this must be disclosed to both the seller and the lender. Failure to do so could result in the lender accepting a price that is below the actual market value of the property, leading to potential claims of misrepresentation. Unpaid liens or second mortgages. The agent must disclose any secondary liens, home equity lines of credit, HELOCs, or other outstanding debts secured against the property that could affect the short sale process. Example: if there is a second mortgage on the property, the agent must ensure that the second line holder is aware of the short sale negotiations and that the second line holder's approval is obtained. Short sale approval contingencies. Agents must inform both the seller and the lender that the short sale is subject to the approval of the lender, which includes agreeing to the sale price, conditions, and any other terms. Example: a homeowner may think they can sell their home for a certain price, but the lender may have different expectations. The agent should ensure that both the seller and lender are aligned on terms before proceeding. Possible deficiency and tax implications. The agent must inform the homeowner about the potential for a deficiency judgment, the remaining debt after the sale, and any tax consequences that may arise from the forgiven debt. Example: if the lender agrees to forgive part of the debt in a short sale, the homeowner could be liable for taxes on the forgiven amount. The agent should clearly communicate the potential for receiving a Form 1099-C for tax purposes. Real estate commission. The agent must disclose any commission arrangements to the seller and the lender. This includes informing both parties about the percentage of the commission and ensuring that it is consistent with lender approval. Lenders often require commission reductions as a condition of approving a short sale. Example: if the lender only agrees to approve a short sale if the commission is reduced, the agent must disclose this fact to the seller before moving forward. Legal and ethical consequences of failing to disclose. Failure to disclose material information in a short sale transaction can lead to serious legal and ethical consequences for the real estate agent. Breach of fiduciary duty. Real estate agents owe a fiduciary duty to their clients, which requires acting in their best interests. Failing to disclose critical information, such as the true condition of the property or secondary liens, breaches this duty and can lead to legal action, including lawsuits for damages. Lender liability. If a lender agrees to a short sale based on false or incomplete information, the lender may have the right to cancel the transaction or pursue legal action against the agent or the seller for fraud or misrepresentation. Civil and criminal penalties. In cases of fraud or intentional misrepresentation, agents could face civil penalties, fines, and even criminal charges under federal or state laws. This could include violations of the Fair Debt Collection Practices Act, FDCPA, or the Arizona Consumer Fraud Act, ARS, paragraph 44-1521, both of which prohibit deceptive practices in financial transactions. Professional sanctions. Failure to adhere to disclosure obligations could result in disciplinary action from the State Real Estate Commission, including fines, suspension, or revocation of the agent's license. The importance of full disclosure to both seller and lender transparency with sellers. The seller needs to be aware of all the implications of a short sale, including potential credit damage, tax consequences, and the possibility of a deficiency judgment. The agent should provide the seller with the short sale seller advisory and recommend that the seller consult with a tax advisor or attorney. Transparency with lenders. Lenders need full visibility into the homeowner's financial situation and any issues with the property. By ensuring the lender is informed of the full financial picture, agents help facilitate the approval process and ensure the lender's expectations are met. Best practices for agents in ensuring transparency. Clear communication. Real estate professionals should maintain open and honest communication with both the seller and the lender throughout the short sale process. Keeping all parties informed helps build trust and ensures that everyone is aligned on the goals and expectations. Consulting legal and tax professionals. Agents should always recommend that homeowners consult with attorneys and tax professionals to fully understand their rights and obligations. This helps mitigate risks associated with legal issues, tax burdens, or deficiency judgments. Documenting everything. Agents should ensure that all documents related to the short sale are well organized and thoroughly documented. This includes email exchanges, forms submitted to the lender, and all agreements made with the seller. Proper documentation helps protect the agent in case of disputes or future legal issues. Key takeaways. Full disclosure. Real estate professionals must ensure transparency in all aspects of the short sale process, including property condition, liens, commission arrangements, and potential tax and legal consequences. Fiduciary duty. Agents have a fiduciary duty to act in the best interest of their clients, which includes providing full and honest disclosure to both the seller and lender. Legal consequences. Failure to disclose material information can lead to civil or criminal penalties, professional sanctions, and damage to the agent's reputation. Collaboration with professionals. To ensure proper disclosure and protect the client's interests, agents should encourage the seller to consult with legal and tax professionals before proceeding with a short sale. By adhering to these guidelines, real estate professionals can navigate the complexities of short sales ethically, legally, and in a way that protects both the homeowner and the lender. Dual agency in short sales. Risks and ethics of representing both parties. Objective. This section will explore the ethical and legal challenges of dual agency in short sale transactions. It will examine the risks involved, the legal obligations of real estate professionals, and how to navigate this complex situation while adhering to ethical guidelines. Understanding dual agency in short sales. Dual agency occurs when a single real estate agent or brokerage represents both the buyer and the seller in the same transaction. In a short sale, this can be particularly challenging because of the complexity of negotiations with the lender, the homeowner's financial distress, and the necessity of transparent communication between both parties. Definition. In a short sale, the real estate professional represents both the seller, homeowner, and the buyer in the same transaction. The agent is responsible for managing all aspects of the sale, including negotiations with the lender and the buyer. However, because the agent owes fiduciary duties to both parties, there may be conflicting interests, especially when negotiating with the lender for price reductions or debt forgiveness. Risks for the agent. Conflict of interest. Representing both parties can lead to conflicts of interest. For instance, the seller's goal may be to secure as much debt forgiveness as possible, while the buyer may want to purchase the property at the lowest price. Lack of confidentiality. In dual agency situations, it can be difficult for the agent to maintain the confidentiality of both parties' positions. Information regarding the seller's financial hardship or the buyer's maximum offer can be seen as privileged and confidential, and sharing this information could compromise the agent's ability to represent each party fairly. Legal risks. If an agent fails to disclose dual agency properly, or if the agent doesn't get written consent from both parties, they may face legal consequences or disciplinary action from their state's real estate commission. Ethical considerations in dual agency. Representing both the seller and the buyer in a short sale requires the agent to uphold a high standard of ethics. Here are some considerations that help ensure ethical compliance. Full disclosure. The agent must fully disclose the dual agency relationship to both the buyer and the seller at the outset of the transaction. This disclosure should be made in writing, and both parties must consent to the arrangement. Example: before entering into the agreement, the agent should present a dual agency disclosure form that outlines the potential conflicts of interest and asks both parties to acknowledge that they understand the arrangement. Neutrality. As a dual agent, the real estate professional must remain neutral and avoid taking sides. They must not disclose confidential information to either party without permission, and must ensure that both parties are treated fairly and equitably. Informed consent. Both parties must voluntarily agree to the dual agency relationship, and they must be informed about the agent's role in the transaction. This includes understanding that the agent cannot fully advocate for one party over the other. Written agreement. Many states require a written agreement for dual agency. The agreement should clearly define the agent's role and responsibilities and should explain how the agent will navigate potential conflicts. Best practices for managing dual agency in short sales: clear communication. One of the most important aspects of dual agency is clear and constant communication with both the buyer and the seller. Keeping both parties informed about the status of negotiations, offers, and lender responses is key to maintaining transparency and trust. Offer alternatives. If there is a potential conflict, agents should offer the option for one party to seek separate representation. For example, if the buyer or seller is uncomfortable with dual agency, they should be allowed to have a different agent represent their interests. Document everything. In short sales, keeping detailed records of all communications and disclosures is crucial. Agents should document all interactions, including communications with the lender, offers made by the buyer, and any changes to terms or conditions. Arizona laws on dual agency. In Arizona, real estate professionals must comply with state laws regarding dual agency. According to ARS, paragraph 32-2156, a real estate agent must obtain written consent from both parties, buyer and seller, before acting as a dual agent. Additionally, Arizona law mandates that the agent must act in a manner that does not compromise either party's interests and must ensure that all actions comply with ethical standards set forth by the Arizona Department of Real Estate, ADREW. ARS, paragraph 32-2156. A real estate broker or salesperson must make a written disclosure to all parties in the transaction that they are acting as a dual agent. This disclosure must be signed by both the buyer and the seller to confirm that they understand the arrangement. Preventing fraud and misrepresentation during short sales and foreclosures. Objective. This section will discuss the various types of fraud and misrepresentation that can occur during short sales and foreclosures and the ethical and legal responsibilities of real estate professionals to prevent such actions. Types of fraud and misrepresentation. Falsifying documents. One of the most common fraudulent activities in short sales is the falsification of documents. This can include overstating the borrower's income, misrepresenting the condition of the property, or inflating the sale price to benefit the seller or buyer. Example: an agent may falsely report a higher income for the homeowner in order to increase the chances of the short sale being approved by the lender. Inflating offers. In some cases, buyers may work with agents to inflate their offers to trick the lender into approving a short sale for a higher amount than the property is worth. Example: a buyer offers $100,000 for the property, but the agent secretly arranges for a side deal with the buyer to purchase the property for less after the short sale is approved. Short sale, flipping. Another type of fraud involves the practice of flipping the property, buying the property at a short sale and then immediately reselling it for a profit at a higher price without properly disclosing the resale transaction. Example: an agent may purchase a distressed property at a short sale for $100,000 and then quickly resell it for $150,000 without making significant repairs or disclosing the resale to the lender. Misleading lender. Agents may also engage in fraudulent behavior by misleading the lender regarding the property's condition, the seller's financial hardship, or the terms of the sale. Example: an agent may convince a lender to accept a lower sale price by falsely claiming that the property has substantial damage, even when it is in good condition. Legal consequences of fraud. Fraud and misrepresentation in short sales and foreclosures can result in severe legal consequences for real estate professionals. Criminal liability. Engaging in fraud can result in criminal charges, including fines and imprisonment. Real estate professionals who are caught falsifying documents or engaging in fraudulent activity may face both criminal prosecution and the revocation of their licenses. Civil liability. Real estate agents who engage in fraud or misrepresentation can be sued by the lender, the seller, or the buyer for damages. In some cases, agents may be required to pay restitution or damages to those harmed by their fraudulent actions. Professional sanctions. The Arizona Department of Real Estate, ADRE, can take disciplinary action against agents or brokers who engage in fraudulent practices. This may include fines, suspension, or revocation of the real estate license. Best practices to prevent fraud. Ensure full transparency. Agents should always provide full and accurate information about the property, the financial status of the seller, and the terms of the sale to both the buyer and the lender. Full disclosure is the best way to prevent any fraudulent activity. Verify all information. Before submitting documents to the lender or agreeing to terms with the buyer or seller, agents should verify the accuracy of all financial statements, property condition reports, and offers. This includes confirming income statements, tax returns, and any other documents that could impact the short sale or foreclosure decision. Educate clients. Real estate professionals should educate their clients about the legal and ethical implications of misrepresentation and fraud. Clients should understand that engaging in fraud can lead to serious legal consequences, and agents should avoid participating in any illegal activity. Work with legal professionals. When in doubt, agents should consult with an attorney to ensure that all transactions comply with the law. In some cases, legal professionals can help draft documents or provide guidance on how to handle tricky situations where misrepresentation or fraud could be an issue. Ethical responsibilities for real estate professionals. Acting in the best interest of clients. Agents must always act in the best interest of their clients while adhering to legal and ethical standards. This includes making sure the homeowner understands their rights and obligations during a short sale and helping the buyer understand the risks involved in purchasing distressed properties. Avoiding conflicts of interest. Agents should avoid situations where their interests may conflict with their clients' interests, especially in distressed property transactions. Agents should not engage in any activities that could harm the homeowner's financial situation or put the transaction at risk. CU box title. Style. Default. Box. Color. 333. Title. Color. FFF. Radius. 3. Class. Content box. Quick quiz. Fill in the blank. Agents should avoid situations where their interests may conflict with their clients. DBM, FITB, answer, interests, SU box, key takeaways. Dual agency and short sales. Real estate agents must ensure full disclosure when representing both the buyer and seller in a short sale. This includes obtaining written consent from both parties and remaining neutral to avoid conflicts of interest. Preventing fraud. Real estate professionals have a responsibility to prevent fraud and misrepresentation during short sales and foreclosures. This includes being transparent, verifying all information, and educating clients about the legal and ethical implications of fraudulent activities. Ethical responsibilities. Agents must maintain transparency, act in the best interests of their clients, and avoid conflicts of interest. Misleading lenders or engaging in fraudulent activity can have serious legal and professional consequences. By adhering to ethical and legal standards, real estate professionals can ensure the integrity of short sale and foreclosure transactions while protecting themselves and their clients from potential legal and financial pitfalls. Guidelines for ensuring fairness and transparency when negotiating with lenders and buyers. Objective: this section will outline the ethical and legal guidelines that real estate professionals should follow to ensure fairness and transparency during the negotiation process with both lenders and buyers in short sales and foreclosure transactions. The importance of fairness and transparency in short sales and foreclosures. In short sale and foreclosure transactions, fairness and transparency are crucial for maintaining trust and ensuring that all parties, homeowners, buyers, and lenders are treated equitably. Real estate professionals must adhere to the following guidelines to protect their clients and avoid legal consequences. Avoiding conflicts of interest. A real estate professional must avoid any actions that could create a conflict of interest between the buyer, seller, and lender. For example, if the agent is representing both the buyer and the seller in a short sale, they must maintain neutrality and disclose the dual agency relationship to both parties. Clear and honest communication. Open and honest communication between all parties is critical in short sales and foreclosure transactions. This includes informing the homeowner of their rights and obligations, ensuring the buyer understands the risks of purchasing a distressed property, ensuring that the lender is aware of the homeowner's financial hardship and the terms of the proposed short sale. Documentation transparency. All documentation presented to lenders, buyers, and sellers must be truthful and accurate. Real estate professionals must make sure that the homeowner's financial information is accurate and that no false statements are made regarding the condition of the property. The buyer is fully aware of any liens, the condition of the property, and the timeline for closing the transaction. The lender receives all the necessary documents to process the short sale efficiently. Key guidelines for negotiating with lenders. Full disclosure to lenders. Example: if a homeowner's financial situation changes during the short sale process, e.g., they receive additional income or assets, the agent must immediately inform the lender. Failing to disclose this can lead to the lender rejecting the short sale and may also lead to accusations of fraud. Rule: always provide accurate and complete information to the lender to avoid any misrepresentation of facts. Negotiate in good faith. When negotiating with the lender on behalf of the homeowner, the agent must act in good faith and attempt to reach a fair resolution. For example, if the lender rejects a short sale offer that is reasonable and within market value, the agent should clearly explain the circumstances to the lender and seek a compromise. Avoid coercive tactics. Example: if an agent pressures the lender to approve a sale at a certain price or within a certain time frame without regard for the lender's position, this can be seen as coercion. It may result in legal repercussions for the agent or broker. Rule: negotiations should be based on factual evidence and fair practices rather than aggressive tactics. Provide comprehensive information. Ensure that all the required documentation is submitted to the lender promptly. This includes the homeowner's financial hardship letter, a market analysis of the property, a breakdown of debts owed, and any other documents requested by the lender to substantiate the need for the short sale. Key guidelines for negotiating with buyers. Transparency and property condition. Example: if the property has significant repair issues or legal disputes, the agent must disclose this information to the buyer before the sale proceeds. A buyer who is not informed about the condition of the property may later file a lawsuit or request a refund if they find hidden issues. Rule: buyers must be informed of all relevant details about the property, including any risks or potential issues that may affect their purchase decision. Full disclosure of short sale process. Example: a buyer interested in purchasing a distressed property should be informed that the short sale process is lengthy, may take several months to complete, and is contingent upon lender approval. Failing to explain this could lead to frustration on the part of the buyer. Rule: make sure the buyer understands that the sale is subject to the lender's approval and that there is a possibility that the lender may not approve the sale, or that it could take longer than expected. Educating the buyer. Example: a buyer may not fully understand the risks involved in purchasing a distressed property, such as issues with unpaid liens or potential repairs. It is the agent's duty to ensure the buyer is fully aware of these risks. Rule: real estate professionals should educate buyers about the risks of purchasing distressed properties, including how to handle the potential for hidden repairs, unpaid taxes, or liens on the property. Ethical practices in short sales and foreclosures. Avoiding fraud and misrepresentation. Real estate professionals should never engage in fraudulent activities, such as inflating property values, misrepresenting the financial condition of the homeowner, or manipulating offers to benefit one party over another. Example: an agent may not present a sale as a short sale when, in reality, the homeowner can afford to pay the full loan balance. Doing so could result in severe legal consequences for both the homeowner and the agent. Rule: agents must be transparent, and all information provided should be accurate and substantiated. Neutral representation in dual agency. If an agent is representing both the buyer and the seller in a short sale transaction, they must maintain neutrality and avoid favoritism. Example: an agent should not divulge to the buyer any confidential information the seller may have shared, such as their maximum acceptable offer or financial situation. Rule: full disclosure and impartiality must be maintained at all times to avoid conflicts of interest and ensure ethical conduct in the transaction. Legal obligations and potential liability. Real estate professionals face significant legal risks if they fail to adhere to these guidelines. Breach of fiduciary duty. Real estate professionals have a fiduciary duty to their clients, both the buyer and the seller. If an agent fails to act in the best interest of one party or engages in fraudulent activity, they could be sued for breach of fiduciary duty. Legal actions for fraud. Engaging in fraudulent activity during a short sale or foreclosure could result in criminal charges or civil lawsuits. For example, misrepresenting the homeowner's financial hardship or the property's condition could lead to charges of fraud and result in severe financial penalties or even jail time. Disciplinary action. Real estate licensees who engage in unethical behavior may face disciplinary actions from the Arizona Department of Real Estate, ADRE. This could include suspension or revocation of their license, as well as fines. Key takeaways. Fair negotiations. Real estate professionals must ensure transparency and act fairly when negotiating with both lenders and buyers. They should maintain clear communication, disclose all relevant information, and avoid conflicts of interest. Avoid fraud. Engaging in fraudulent activity or misrepresentation can lead to severe legal consequences, including lawsuits, license suspension, and criminal charges. Ethical conduct. Agents must uphold the highest standards of ethical conduct, avoiding any tactics that could harm their clients or the integrity of the transaction. By following these guidelines, real estate professionals can ensure that they handle short sales and foreclosure transactions ethically and legally, protecting themselves, their clients, and all parties involved in the process.